Welcome. As philosophers, we're always grappling with these big questions, right? Like, what is law? What makes something morally right or wrong? What are our obligations to each other and to society?
Exactly. These are the core issues.
And today, we're going deep, really deep, into a tradition that's been wrestling with these questions for centuries. Natural law theory.
And we're going to be using a fantastic resource for this, the Stanford Encyclopedia of Philosophy entry on natural law theories.
Perfect for us, philosophy nerds. So what's the mission here? Well, we want to unpack the heart of natural law theory, especially how it applies to the philosophy of law. We'll explore how it relates to the actual laws we see in the world, positive law, and tackle those age-old questions about justice and why we feel bound by rules.
This is going to be a structured exploration, but we're going to make it a conversation, a journey through ideas.
Exactly. And don't worry, we know this stuff can get complicated.
We'll be your guides, making sure you don't get lost in the jargon.
Okay, so let's get philosophical. When we talk about natural law theory, specifically as it relates to law, what are we really talking about? How do we define it?
Right, so the Stanford Encyclopedia entry makes a crucial point right off the bat. We're focusing on natural law theories as theories of law, not just broader natural law ideas about ethics or politics, which are out there, of course.
Like Aquinas' whole ethical system.
Exactly. But today, it's about how natural law thinkers see law itself. What is it? What's its purpose?
Now, a lot of people think natural law theory is totally opposed to legal positivism, that idea that law is just what humans decide it is.
Yeah, and that's a misconception. In fact, Aquinas, the big name in natural law, actually coined the term positive law.
Why, really?
Yeah, and natural law theories actually share a lot with positivist views. They acknowledge that law is a social thing, influenced by power and custom.
So where do they split? What's the fundamental difference?
It boils down to whether natural law itself exists. Positivists say no, law is solely a product of will. Natural law theorists say yes, there are these principles of reason and morality that inform and shape what law should be.
So it's like there's this extra layer, this grounding in something beyond just human decisions.
Exactly. They see positive law having this dual character. It's a social fact, something we can observe, but it's also supposed to be a set of reasons for us to act in certain ways.
Okay, I'm starting to see the distinction, but what about that famous line, unjust laws are not laws? That sounds like a pretty direct attack on positivism.
Well, it's more nuanced than that, especially for a philosopher. It's not denying that an unjust rule might be on the books, officially part of the system.
So it's not just saying this bad law doesn't exist.
Right. The point is that a law, to truly be law, has to give us good reasons to follow it. If it's deeply unjust, it fails in that. It's deficient as law.
Like it's missing something essential to what law should be.
Exactly. And the entry points out much of the positivist critique loses its force because natural law theory already recognizes law as a social reality. It's not just some idealistic moral fantasy.
Interesting. So it's not about whether an unjust law exists, but whether it can truly claim to be law in a full sense.
Exactly. And Orego, who's mentioned in the entry, makes a fascinating observation. He says even mainstream legal theories today, even if they don't call themselves natural law, often rely on natural law ideas in practice. Like the idea that law creates reasons for action, or that those reasons can be overridden by serious injustice.
So it's sneaking in there even though they don't always admit it.
Yeah, it's like they're using natural law concepts without necessarily having that whole philosophical foundation in place.
So if we had to nail down the central question that natural law theory tries to answer, what would it be?
It's this. How does law, whether it's a statute, a judicial decision, or a custom, give us good reasons to act according to it? How does it go from just being a thing in the world to having authority over us, especially for rational people?
That's the core of the puzzle, right?
Yeah.
How does legal validity become something that binds us?
Right. And natural law theorists stress the importance of what they call law's source-based character, meaning where it comes from matters. If it's properly enacted by a legislature, for example, that gives it a certain weight.
It's like a pedigree, a lineage that gives it legitimacy.
Yeah, and they argue that this is essential for law to work, to promote the common good, to protect rights, to have integrity.
But there's also this awareness within natural law theory that law can be misused, right? That it can become a tool for bad things.
Absolutely. That's always been a core concern. It's the flip side of the coin. They see law as a necessary tool, but one that can be twisted if moral principles aren't followed. It's like a remedy for both anarchy and tyranny.
Because tyrannies offer just lawlessness dressed up as law.
Precisely.
Now let's get into the word natural itself. For philosophers, this word is loaded. What does it really mean in this context?
Well, the entry is pretty clear on this. In natural law theory, natural basically means rational. It's about what's in accordance with reason. Aquinas emphasizes this a lot.
It's not just some vague appeal to nature, like, oh, the birds do it, so it must be natural.
No, it's much more rigorous than that. It's about principles we can grasp and justify through careful thinking, through practical reason.
And this isn't just wordplay, right? There's a deeper reason for this connection between natural and rational.
Absolutely. Aquinas has this whole methodological framework. It links a thing's nature to its capacities, to how those capacities can be realized, and then to the good things those realizations aim at. And all of this is guided by practical reasons.
So it's grounded in a whole understanding of how we know things, how we act, what's good for us.
Exactly.
But even though it's based on reason, does factual knowledge play a role in natural law theory?
For sure. It's not like they're ignoring the world around us. For instance, we know that humans have the capacity to learn, and from that we can infer that pursuing knowledge is good, or we observe human vulnerabilities and needs, and that informs our moral principles about helping others.
It's like the facts on the ground help us understand what's reasonable, what's morally right.
Yeah, and they also give us a basis for specific institutions. Like the fact that resources are scarce helps justify the need for property rights in a just society.
So it's reason and experience working together.
Exactly.
Now, let's shift gears a bit and talk about political authority and the rule of law. What's the natural law take on these big philosophical ideas?
Well, they argue that political communities arise naturally, you could say, from basic moral and practical principles. We need to cooperate, to flourish, to protect ourselves, to achieve common goals.
So it's not just some random social contract we invented, but something more fundamental to being human.
Right. And government, they say, is the normal way to make those specific rules and regulations, what they call determinations, that put those general moral principles into practice.
Okay, so the government's role is to take those big, abstract ideas and make some concrete, livable rules.
Precisely.
And this leads to that whole idea of the rule of law, not of men, right?
Absolutely. They see this as the ideal.
Why? What's the philosophical justification for that?
They draw a lot from Aristotle on this. He argued that laws, being based on reason, are less prone to bias and corruption than individual rulers. He warned against tyranny, that danger when one person has unchecked power. Plus, there's the principle of equality, everyone being subject to the same laws.
It's about fairness, consistency, preventing abuses of power.
Exactly. And then you have Aquinas, who adds to this. He sees the ideal form of law as coordinating the actions of free individuals through clear, public, general, stable, and practical rules. So it's treating people as partners in reason, not subjects to be controlled.
I see. And how does Fuller's work on the rule of law fit into this tradition?
The entry points out that Fuller's 8 principles of the rule of law are really a modern take on ideas that go back to Aquinas. Like, laws should be publicized, understandable, not retroactive. He argues these principles are essential because they embody this moral duty of rulers to treat the people they govern as free and equal.
Not just as pawns to be moved around.
Exactly. It's about mutual respect between the government and the governed.
Now, some people, like Raz and Kramer, argue that the rule of law is morally neutral. They use that image of a sharp knife, which can be used for good or evil.
Right. They say that even bad regimes can use the rule of law effectively to achieve their aims. But Finnis and Simmons push back on that, especially on whether tyrants really follow the rule of law, particularly the idea that they themselves should be bound by the rules.
So it's a debate about whether the rule of law inherently promotes good governance or just provides a tool that can be used in different ways.
Right. But the key for natural law theorists is the moral dimension. They're concerned with what a fully rational and moral legal system would look like, not just what works in a purely practical sense.
So beyond just the procedures, natural law theory also talks about the substantive goals of law, right? Like preventing violence, protecting property, things like that.
Absolutely. It's not just about how laws are made, but also what they aim to achieve. And this is where the idea of ascitus gentium, the law of peoples, comes in. These are principles and rules that are seen as essential for any society to function peacefully.
Like a basic moral code for how we get along.
Yeah, and the entry argues that this is the basis for many modern legal concepts, like general principles of law recognized by civilized nations, or even the idea of human rights in international law.
So it's like these fundamental principles are woven into the fabric of how we think about law and morality.
Exactly. And for Aquinas, these principles are derived from even more basic moral precepts like do good and avoid evil. In common law, there's a similar distinction between mala in se, things that are wrong in themselves, like murder, and mala prohibita, things that are wrong because they're prohibited, like parking violations.
Okay, I'm seeing the connections here.
Yeah.
But what about purely positive law, the specific rules that governments create? How does natural law theory justify their authority over us?
Well, they use this concept called determinatio, which means determination or specification. They say that positive law gets its legal status from being properly enacted, but it also carries this moral obligation, a presumptive one, for those subject to it.
So just because a law is on the books, that doesn't automatically make it morally right.
Right. Aquinas argued that ideally those positive laws should be rooted in natural law principles, but even if they are, their legal force comes from being part of the system.
Okay, I'm a little fuzzy on determinatio. The entry uses this analogy of a maternity hospital. Can you explain that?
Sure, so the need for a safe place to give birth. That's a basic good, a principle. But the details of how that hospital is built, the rules they have, those are specific choices made by humans. That's determinatio, taking a general principle and making it concrete.
So it's like filling in the blanks, the specifics of how to achieve that good.
Exactly. And lawmakers have some freedom in doing that, but it should be guided by reason, aiming toward that good.
So when they make a law, it creates a reason for us to act a certain way. But how does that square with the idea that we can't derive an ought from an is?
Good question. The entry explains that determinatio works as the second premise in a kind of practical syllogism. So the first premise would be something like traffic should be regulated for safety. Then, the law enacting a speed limit, that's the social fact, the second premise, it's not a strict logical deduction, but more like a reasoned specification.
So moral weight comes from that initial principle, the need for safety, and the law is just the concrete application of it.
Right. And this is why positive law has this presumptive moral force. It's supposed to fit within a scheme of practical reasoning that starts with basic moral needs.
And this is where natural law theory and legal positivism actually agree, right? They both acknowledge that laws depend on social facts.
Exactly. The difference is whether those social facts are the only thing that matters.
Okay, now, you've mentioned this phrase, presumptive and defeasible obligatoriness. What does that mean for us as philosophers thinking about the nature of obligation?
Well, it's about how legal obligation relates to moral obligation. Contemporary legal theorists like Raz and Hart have talked about how legal authority gives us these exclusionary or preemptive reasons for action.
Meaning they override our other reasons.
Yeah, to a certain extent. When a legitimate authority tells us to do something, we're supposed to treat that as a reason that replaces some of our existing reasons.
Just because they have that authority within the system.
Right. And this content independence, the idea that we follow the law regardless of whether we personally agree with it, that's what creates this presumptive obligation.
So we're obligated to obey even if we don't like this specific law.
Well, there's a presumption that we should, but it's defeasible, meaning it can be overridden. If the law goes against really fundamental human needs, goods, or principles, then that obligation can be defeated.
So it's not absolute. There are limits.
Exactly. And those limits are where that natural law framework comes in, providing the basis for those moral considerations.
So we have this tension. We need laws to be generally effective, which means they need to have this presumptive authority. But that authority isn't unlimited. It can be overridden by more fundamental moral concerns.
Precisely.
Now, let's talk about this idea that human persons are the point of law. That seems like a really important philosophical concept.
Absolutely. Natural law theory says that people aren't just subjects of law, creations of the system. They're the reason law exists in the first place. The entry draws this connection between ancient Greek and Roman philosophy and modern human rights. Like the Universal Declaration of Human Rights, it traces that back to Roman ideas about natural freedom and equality.
So law isn't just this abstract system floating above us. It's grounded in our humanity.
Right. Roman law even had this concept of the final causa of law, the ultimate purpose, and they said it was the human persons for whose sake law is made. This contrasts with some older positivist views, like Kelson's, which basically said that person was just a legal category, not something with inherent value.
So it's a shift from seeing people as subjects of law to seeing law as serving the well-being of people.
Exactly. And Finnis, who's mentioned in the entry, argues that recognizing the equal dignity of all people is crucial for a rational understanding of law. It's not about privileging a particular biological species, but about affirming that persons, beings with reason, have inherent rights.
So we're not just objects to be regulated. We're the reason for the whole system.
Exactly.
Okay, let's tackle the big one, the most famous and maybe most misunderstood claim of natural law theory. Lex injusta, non est lex. An unjust law is not law. Does this mean they're saying that a bad law simply isn't a law at all?
Well, it depends on what you mean by is not a law. The entry says it depends on the context. Sometimes it means that a law, even if it's officially valid, lacks the moral authority to demand our obedience.
Like we might have a moral right to resist it.
Right, but other times it's more about the nature of law itself. If law is supposed to be about justice, then a deeply unjust law fails to be law in a fundamental way.
So it's like saying a square circle isn't a circle. It might have some features of a circle, but it's missing something essential.
Exactly. The entry draws parallels with other phrases like, an invalid argument is no argument. We're not denying that a bad argument exists, but we're saying it fails to meet the criteria of a good argument.
So an unjust law might be a law in a formal sense, but it's defective. It's missing the moral core that makes it truly law.
Right. And Aquinas actually used more nuanced language than that slogan. He would say things like unjust law is not straightforwardly law, or it's a perversion of law.
Yeah.
He recognized the complexities.
So he was more careful with his wording. But even he used similar shorthand phrases for other ideas, like saying unjust judgment is no judgment.
Right. So maybe it's a way of emphasizing the point, even if it needs more explanation.
Now, Hart criticized that slogan, saying it discourages people from engaging in moral critique of the law.
Yeah, but the entry argues that's actually backward. The very idea that an unjust law isn't fully law relies on moral judgment. You have to evaluate whether it meets those standards of justice that natural law theory says are inherent in law itself.
So it's not shutting down moral critique, it's actually inviting it.
Exactly.
What about those who say that even unjust laws must be obeyed for the sake of order and certainty?
Right, some philosophers, even some drawing on natural law ideas, emphasize that. They worry about chaos if everyone gets to decide which laws to follow. But the entry points out critiques of that view, like Alexi's argument that it's inconsistent to say we have a moral duty to obey something that's morally wrong.
It's a tough philosophical nut to crack, and there's still debate among contemporary thinkers like Alexi, Finnis, and Crow about how to best understand and apply that classic natural law position today.
Definitely.
Okay, last big question. Can any theory of law, natural law or positivist, truly be value-free, especially morally value-free?
The entry argues that no, not really, especially when you're building a general theory of something as complex as law. Just choosing which concepts to focus on, how to arrange them, that involves value judgments. You're implicitly saying what you think is more rational, more important.
So even if you don't explicitly say this is good, this is bad, you're still making choices that reflect your values.
Exactly. They use Weber as an example. He talked about value-free social science, but even his idea of rational domination implies certain values about what's good for humans.
So those values are always lurking there, even if they're not stated outright.
Right. And natural law theory just makes those values explicit. It puts them on the table for debate, for rational scrutiny, like we see in Aristotle.
So it's not about being unbiased, but about being transparent about your biases.
Yeah, and being willing to defend them. And the entry emphasizes that this doesn't mean they ignore bad laws. They study them precisely because they're bad, because they deviate from a morally good system. The goal isn't just to describe law, but to figure out what makes it just, what makes it worthy of our obedience.
And they argue that this is something that legal positivism often misses, that it focuses too much on just the facts of law and not enough on its deeper purpose.
Right. The entry actually says that maybe no legal philosopher should be a legal positivist because natural law theory already accounts for those social facts that positivists emphasize. It's just that it goes further.
It asks those bigger questions.
Exactly. Questions like, what's the point of law? Why should we obey it? What laws should we have? These are the questions that matter.
So it's not just about the label natural law. It's about grappling with those fundamental issues that any theory of law should address.
Exactly.
So for a fellow philosopher listening to this, What are the key takeaways from our deep dive into natural law theory?
Well, we've seen how it grounds law in reason, how it sees positive law as important but not the whole story, how justice is central to its conception of law, how that slogan about unjust laws is more nuanced than it seems, and how value judgments are unavoidable in any theory of law. It's a richer, more complete picture than just focusing on the is of law.
Absolutely. And it leaves us with this question. If we take seriously these moral dimensions of law, how does that change how we think about the legal systems we live under? Does acknowledging a higher law, these principles of justice accessible through reason, give us a stronger basis for critique and reform?
These are big questions worth pondering, and we encourage you to dive deeper into the Stanford Encyclopedia entry and explore the work of the thinkers we've discussed: Aquinas, Finis, Hart, Dworkin, Raz. This is just the beginning of a fascinating and important philosophical journey.
And who knows where that journey might lead us? That's the beauty of philosophy, right?
Thanks for joining us.
Absolutely. It's been a pleasure.